Every- a very warm welcome to everyone. Thank you for joining this session. I'm sure we found the first session valuable and extremely informative. I hope you have completed the form for attendance that was circulated earlier. We shall begin the second session now. I am Simi Zakaria from second year LLB and will be moderating this session. What's in a moot? Facets of mooting. Moot court is an activity for law students in order to provide students with a platform to litigate as well as to boost their confidence by sharpening their legal skills. Moot as an adjective means something that is open for discussion or open for debate, where students argue hypothetical cases for practice. A moot court competition simulates a court hearing which enables the students to analyze a problem, research the problem, prepare written statements, and present oral arguments. During this session, we have students from the Moot Court Society of St. Joseph's College of Law who will be explaining essentials of and the process of mooting step by step in order to enlighten us about mooting. First, we have Himali Sylvester from 4th year BLLB on the essentials of moot.
Good morning, everyone. I'm Himali Sylvester, and I will be dealing with essentials of mooting today. So first and foremost, what does mooting mean in English parlance in a normal literature language? The word moot simply means an issue that is contested, an issue that is open for debate, and an issue that's open for dispute and is uncertain. So I will slowly walk you through how this literary definition of moot is relevant for a law student. But before that, we'll learn what the objectives of mooting are. So the objectives of mooting are one, to engage students into into different aspects of legal issues. Second, to inculcate the tricks of advocacy and legal research. Thirdly, what does happen in a mooting exercise is that you learn to work in a team with your peers. Thirdly, it also inculcates that remaining interest that one has in the legal area and with other legal issues, and it also helps one in prospective areas of job seeking. So with this, we move on to what a moot court competition means. A moot court competition, in its real sense, is that it's a simulation of a court. So whatever happens in a real court scenario actually happens in a moot court as well. So there's a judge that enters. There are two mooters. So like in an actual court, there are two advocates. There are two mooters in a mooting. They're participants. So in a moot court competition, there are two mooters. So the judge, there's a clerk as well. The judge addresses the matter in the same way. The mooters are expected to present their arguments like the advocates do. There's an adjournment that's done, and the judge is also expected to give a short judgment, which is usually in the form of a feedback, usually, more than in the form of a judgment like in real courts. So how is mooting different from public speaking or debating? Debating is not the same because debating is a more wider issue. And mooting is only relevant to legal area. It only entails whatever happens in the legal arena. So it deals with things related to legal issues only. And in a moot court, you observe a lot more gestures and particular rules and rubrics than in a debating exercise, and therefore it's a lot more different from public speaking and debating. Public speaking and debating have your own styles, but in mooting, there's only one specific style that people are expected to adhere to, and those are courtroom established rules. Next, we move on to the basic processes in the mooting. The basic processes in the mooting involve 4 stages. One is a problem is given and you analyze the problem. The analysis of the problem is done by using a law. So instead of just analyzing the problem normally, law is used to bring in to substantiate that particular issue. Then that issue is recorded in the form of written submissions. What in the moot court language people call written submissions or memorials are the ones that are drafted. Finally, the final stage of moot court involves oral arguments, where the same arguments that one has in the written submission is presented as oral arguments. Next, we move on to the team composition of a moot court. The team composition of a moot court includes 2 speakers and 1 researcher. The speaker, as the name suggests, speaks and is more relevant during the oral rounds, while the researcher helps with written submissions into going on to into various aspects of legality that exist. There are also international moots that allow for 5 participants. So there are 3 researchers and 2 speakers. However, in the oral rounds, only 1 researcher and 2 speakers are allowed to be there. These are international moots alone. So now we'll go to certain legal terminologies that are there in moot court. And for that, I'd like your interaction. Guys, you can just unmute yourself and come in as I ask you the questions, as I ask you questions on the legal terminologies. I will first explain the basics and then go on to asking you questions on that. So a moot proposition. What is a moot proposition? A moot proposition is the document that the organizing institution gives, which has a legal issue written in it. The document is usually more than 6 pages, and it has the entire legal issue elaborated and detailed. Then comes the next stage, which is drafting. What does drafting mean? As I told you before, written submissions. Those written submissions are drafted in a particular format, and that is the process of drafting. And that written submission is also called as memorial or memorandum in different situations. Now, I'd like the participants to tell me if any of you know what PIL is. So, is there any taker? Just unmute yourself and go on to explain what a PIL is.
Public interest litigation.
Okay, can you explain a little more on that?
It's a bit, can I do that? It's basically done.
I'm sorry, come again. I think your voice is quite...
Go ahead. I think there's a network issue from my end. Sorry.
All right. No problem. So yes, so he's right. PIL stands for public interest litigation. It simply means that somebody who recognizes a public interest problem is allowed to go to courts and ask the court to deal into the matter. It has to be a matter concerning social interests, as in public interest. It has to be a public problem. It should concern a large population. Okay. So the next we move on to what a writ petition is. Anybody who knows what a writ petition is?
It's a direct appeal to the Supreme Court.
All right. Can you tell me under which? Can you tell me under which article of the Constitution? It's. Did you say it's a written order?
A written order given by any particular body or institution.
All right. No. So a writ petition is an exclusive jurisdiction that only the High Court and the Supreme Court has. One can use writ petition as under Article 226 before the High Court and under Article 32 before the Supreme Court. So these are exclusive jurisdictions, and these are specifics that you will learn eventually. My subsequent moderators will tell you about the more details of writ petitions. Guys, also, can I request you to raise hands? All right. Next, can anyone tell me what civil petition is? Or give me the distinction between what a civil petition and a criminal petition would be.
Civil petition is when the dispute is among 2 parties, and a criminal petition is when it is which affects the society at large, like something more of a criminal nature.
Okay. Yeah, you're half correct and half wrong. Civil, of course, as the name itself suggests, is a petition that is before the civil courts and relates to civil matters, and criminal petition is, as the name suggests, related to criminal matters. The only difference is the remedy that you seek. But in criminal, the remedy is usually punitive, and in civil, the remedy are of different natures, like pecuniary, injunction, and special damages, which you will read eventually. But right now, you just need to know the difference between civil, criminal, and writ petition, because these are the 3 different ways in which one submits, one gives in the written submissions. So now we move on to the next terminology, which is important, which is the Bare Act. Bare Act is basically the act which just states provisions of the act, and there's nothing more in it. That's the Bare Act. So it has exact words that are there in an act, and it's compiled in the form of an edition or a book. So then there's the bench. Bench is the one that presides over your moot court. So the bench of the collection of judges are what one calls benches. So when in a moot court, you address the bench collectively as your lordships or your ladyship, and you can collectively address them. Then, as I've already told you, oral rounds are the rounds where arguments happen. Okay, so now we move on to what rebuttal and sur-rebuttals are. Does anybody want to guess what rebuttals and sur-rebuttals are? I mean, anybody that debates would know this. Yes, go on.
Contradictory statements being posted when being said.
Contradictory in the sense of, can you elaborate a little more? Is it in the form of questions or just statements?
In the form of statements and evidences in order to contradict some particular statement which has been said already.
Okay, so fine, yes, you're right. So rebuttals and sur-rebuttals in a moot court, I will explain it to you. What does happen is there are two sides. There's one side which is usually the plaintiff or the petitioner, and there's a defendant or the respondent. So the plaintiff or the petitioner is allowed to make a statement which is not in the form of a question, but in a way that contradicts the other party and brings out their argument. So they are allowed to reply to that, and also in the same manner ask another and make another statement which is like a question, but not exactly a question. So that's where the trick is. So the rebuttal is the one that the plaintiff or the petitioner gives. The sur-rebuttal is the next statement that's made by the other party. All right. Anybody can tell me what pleadings are? Yes.
Yeah, pleadings are the written statement of the plaintiffs or in any civil acts or any civil cases.
Yes, you're right. So pleadings are written statements. They're just different when you directly go and give it to the court. At what stage in the court in your process you give it is what matters. So that's the only difference between written submission and pleadings. So now we move on to learn types of moots. So moots can be divided on the basis of three things. One is on the procedure that's used while mooting. Second is the area of law that it focuses on, and the level of competition. So when we look at the procedure based, as I told you before, it can be civil, it can be criminal, and there's a third criteria, which is arbitration. Arbitration is like an outside court. It is an outside court settlement. So it has different forms, and it's a special kind of mooting. But civil and criminal are the general sorts of moots that you will find. Then depending on the areas of law, we know there are various areas of law, but most moots as beginners focus on constitutional law and human rights. But there are also different emerging fields within law which have increased their specificities now. So for instance, there's tax law, so specific tax law firms in amalgamation with certain institutions organize tax law moot courts. Corporate laws, of course, there's a company law moot court the moot courts related to company law and its corollaries happen as well. But these are very specific moot court competitions. Most general ones are based on constitutional law and human rights. And the level of competition, moot courts can also depend on level of competition. There can be a national level competition and international level competition. The national level, as the name suggests, is within the territories of the country. International round is you go abroad, but there are two things there. Sometimes you will have to go for a national level competition, qualify in the national round, and then go to the international moot. Sometimes there's also direct participation. So that completely depends on which moot you choose to go to. Now I'd like to bring to your notice certain important moots. So we begin with national moot courts. Always the NLS moots are the best. So the NLSIU arbitration moot competition organized in Bangalore is one of the best national moot courts. The second is the one organized by Government Law College, Mumbai. Then there's the Bar Council of India that organizes a moot court competition as well. Then you have other two NLUs. One is the NLU of Calcutta and NLU Jodhpur, which organizes these competitions. Then we have within Bangalore, again, NLSIU, of course, is the best within Bangalore, but there are two other important colleges that also organize good moots. One is School of Law, Christ University, and ULC Bangalore, which also organizes an All India moot court competition. So there are very well-known moot court competitions, such as in the international domain, and that include the first one is the arbitration moot that's organized by Hong Kong. Then there's the Oxford International one that organizes one on intellectual property. Then there's the Red Cross International that organizes on international human rights. So these are really important moots that a lot of representation is received from the Indian territory, and a lot of law schools send their students there. So now we move on to how to choose a moot. It's very simple. We have Google. You go on Google, and there are 3 important websites that focus on how you can keep a tab on your moots. One is Law Octopus. It has regular updates on moots. It has pre-invites of moots and has all information related to mooting in there. Then there's Live Law, which also notifies regularly. And there's one more website, which is Bar and Bench, which also notifies regular competitions. So you can choose your moot based on your area of interest, one, of course, but your area of interest is not enough, because sometimes, for instance, I'm interested in space law, but I cannot necessarily go for a space law moot court competition because I have not learned anything about space law. So in that manner, you will also have to look at the subjects that you've learned or subjects that you have a good grasp of, and then you go and choose your competitions. Of course, an important caveat to keep in mind is that you shouldn't have prior commitments. So your moot court is a commitment of about 2 to 3 months actually, but 1 or 2 months is like a mandate. So you should make sure you don't have any prior commitments, and you should also form a team where all your team members are interested in the same thing. So with that, I come to an end of Essentials of Mooting. Thank you everyone for listening. Over to you, Simi.
Thank you, Himali, for that informative and very well researched presentation. We shall begin the next session in a minute. We have Shazia Sheikh from Third Year LLB for Behind the Scenes.
I think my audio went through. I hope the screen is visible. Simi, is it visible? Could you just give me
Yes.
a heads up? Well, there seemed to be a little technical glitch there. We shall begin with. I hope my screen is visible to everyone. So we will be.
Yes.
This is going to be. This is going to be a little intensive because I will be dealing with what exactly goes behind making a memorandum and how do you research for a memorandum. The main core of any moot court competition. So how do you prepare for it? That is the most important question, and many of them think it's going to be really difficult. So they sort of they back out. So let's begin with this. This is going to be a starter for you all. I hope I'm clear. You can ask any of the questions at the end of the session. Now, let me tell you, research is the most important part of any mood preparation, and research never ends, not even on the day of the mood. However, drafting and formatting of your memorial is also very important. Now, memorial is also called as memorandum. So, this is very important, and many people tend to forget the importance of a good memorandum. Also, the memorial score is one of the reasons for low team marks. Remember, there is a reason why they have an award for best memorial. So let's start with what exactly goes behind the scenes. Now, there are two main aspects, like I said before, we'll be discussing. The first one is on research, and the second one is drafting the memorial. All right. Now, let me tell you beforehand, the method stated herein is only a suggestion to you all. You may choose to work differently because team dynamics differ. So, you're free to choose your own way of research and drafting. Now, research, I will be discussing it in three parts. The first is the preliminary, what are the preliminary steps that you need to take before you start with your research. The third is how do you tackle the issues. Every proposition, like I hope you're familiar, thanks to Himali, she said a proposition is the mood problem. So every proposition has issues. So we'll be tackling that, and then the main research. What exactly goes in the main research? The preliminary steps start by reading your mood problem a couple of times until you get hold of the facts. Read it numerous times. I would suggest what we do is we all read it numerous times because each time you read it, you get a different perspective or you get a different fact that will always be helpful in your case. Make a timeline. Draw a timeline of events. So this will help you understand the relationship between the parties or the sequence of events. Pay attention to details such as the dates, place, persons, courts where suit and petition is filed. Also, note down all the provisions of law mentioned in the problem. Note down those provisions of law as well as the statutes which you think are relevant to the case. There will be many, let me tell you. And then next, before that, it's very important to determine the jurisdiction and nature of the case. Now, what happens is many a times people do not get the jurisdiction right. Neither do they get the nature of the case right. When I say nature, what do I mean? Uh, if it is a writ, what kind of writ is it? Is it a certiorari or a mandamus? You need to be very, as in, this will help you understand your prayer. All right. So is it a PIL or a writ petition? Any other writ petition? So it's very important to understand the nature of the case. Next, read the Bear Act. It's very important. I cannot stress it enough. The Bear Act sometimes gives you the answer. So this happened with me in one of my first moots, where the answer was the clue was right in the Bear Act, and we realized it while reading the Bear Act. So that is very important. Next, refer. Also, before that, if you're dealing with a new statute, say example a statute that's just been introduced, start by thoroughly reading the index of the act and rules and mark the provisions which may be relevant to all the as in all the problems in the proposition, and read them together. Look up for recent amendments or landmark case laws. Amendments, guys, it's very important. You look up because sometimes people miss out on the amendments and then the judges grill you on that. So, for ignorance. So look up for landmarks and landmark judgments in respect of the act. Make sure the statute you're reading is one of the recent one. If it is, in case there is a recent amendment, that is. And since the mood deals with and if the mood deals with any ongoing crisis, you can start reading newspaper articles to get through a thorough understanding. Also look out for legal articles in this matter. Articles written by legal blogs such as Bar and Bench, Live Law, Legally India, and there are many more. I usually go to Bar and Bench and Live Law because they give you a detailed perspective into the matter, a legal perspective, that is, and that will help you draft your arguments as well. So these articles would concentrate on the legal perspective, which will help you while drafting. Next, also see if you can find any ongoing petitions. So the last point that I have mentioned in the PPT, that is ongoing petitions, usually you will find, for example, in the month of March, we had many moots that were on CAA. So there were petitions filed already. So what we did is we looked up the petitions, we read the petitions to look up the arguments that are provided in the petitions. You can use those arguments, you can use those cases to enhance the quality of your memorandum. So, and although the matter may be sub judice, but you can always use it. Use those arguments and the case laws if you find them well enough, if they are in sync with your line of argument. So once you have a basic understanding of the facts, the law, the news, and all the other elements, read the problem keeping in mind as a petitioner. Okay. You remember at first you need to read it as the counsel of a petition and then the respondent. Mark, highlight all the facts. I would suggest you take a printout of the proposition. Take 2 printouts. So first read it as a petitioner, highlight the points, facts as a petitioner, then switch to the next printout, highlight the facts as a respondent. So this way what happens is your chances of interpreting the problem differently increases. You do not mix things as a petitioner and a respondent. So always, it's advisable to take 2 different printouts. So this was about the preliminary steps. I hope I'm clear. These are the essentials before you start with the main research. The issues. So read the proposition, like I've said, and highlight the relevant facts. Repeat it as a respondent. Sit with your teammates, brainstorm, frame issues, or if the issues have already been framed, you're lucky if the issues have already been framed, or else you have to frame the issues for a problem. Try to restrict yourself to 3 issues, 3 to 4 issues maximum, and start discussing what is your basic line of arguments. Because by now you should be knowing what goes into each issue, and you shouldn't be clueless about any of the issues. Then you can divide the issues among your team members and start working individually on each issue. If one person takes up one issue, he or she should be able to deal with it from both the sides, that is the petitioner and the respondent. With this, next you begin your research. Now, there's a little tip that I would suggest that before you begin with your research, drop a timeline, set deadlines as to when your first issue should be done, when your second issue should be done, and so on. Always discuss, guys, always discuss with your teammates about your findings. Even though you have divided the work, share links, readings with your teammates when you come across something useful and noteworthy. This helps in having all the teammates on the same page. The main research, now this is the part that you all will you all might be looking forward to. How do we do the research? What exactly do we, how exactly we go about it? So there are three things generally that people opt for. So the first one is the books, online, and the experts. Now, books, commentaries, I cannot stress enough on the importance of books. What we have not found online, we've always found it in books. So make books your best friends. I know they're huge. They look really scary at the beginning, but I'm sure once you open them, you'll understand what exactly am I trying to say here. Their commentaries, we have it in our libraries. Commentaries are very important. So what commentaries do is they help you understand the law. They so these commentaries, a barrack has the provision, but it's important to understand what the law says. So read the commentaries. It gives you the law as well as case laws. You will get numerous case laws there, relevant ones. So read that. Law lexicon next is this is the legal dictionary. Go make so at one of the moots, the judge there said, make law lexicon your best friend, and till date it is my best friend. So I will pass on the same advice to you guys. There are many Supreme Court dictionaries as well. There are many books that we have it in library, very useful. Start with the law lexicon. Then you move on to the specific law. For example, if the problem is on IPR or transfer of property law, so what you do is you take up those books, you read them again and again to understand which provision is relevant. Where does your remedy lie? Where can you prove the other party is wrong? So these books will help you. Then go on to the specific law. Then you have the supplementary reading. There are many other books. Maybe in the library you can see, for example, if you're dealing with company law, you can also pick up contract law and then just go through it to understand. Always make sure you know your constitution at the back of your hand. I mean, all the provisions of the constitution, because you can expect questions on your basis. Next is the online. Well, although I have written here as Manupatra, SEC Online, Indian Kanun, Google, I start my research from Google. What happens is you get some lead there. And Indian Kanun, like Advocate Vikhyat Oberoi also said, Indian Kanun has cases of district courts as well. So cases which I have not found on Manupatra, I have always found them on Indian Kanun. So guys, do not neglect the importance of Indian Kanun. Manupatra, yes, it's important. We shall have a session on Manupatra, how to use Manupatra for you guys. And luckily we have it in our college, Manupatra. We have access to Manupatra in college. So we'll have a session. We'll teach you how to do it for the freshers. And SEC Online is also one of the legal databases that you can look up. The last one is the experts. Well, you can go approach experts, academicians, technical experts. So one of our moots was on data privacy. One of our faculty helped us get in touch with an expert on data privacy. We went, met him. He gave us a different perspective, which we included in our memorandum, and you can always use that. So this was about the main research. Have a base. Also, once you have the research, you have a basic draft of arguments, and even if they're one-liners or bullet points with links to sources, you can share them with your teammates. After a week or so, depending on your timeline, when you're done researching for your issue, switch the issues, all right, and see if you can find something more or anything different apart from what has been already found by your teammate. With this, everyone should be able to speed about each issue. Always draw a timeline. So these are a few tips that I would suggest before I go on to the next part. That is, always draw a timeline and try your best to stick to it. Ensure your teammates are also following the timeline and not falling behind, because that happens a lot. So all of you have to work together, sit together to draft the arguments, Language and style of writing differs from person to person, and uniformity has to be maintained throughout the memorandum. Also, try finish drafting 1 week before submission in order to have ample amount of time to proofread, format, vet, and then print the document. Always check the rules of the competition, people, because the rules are very important. Time and again, you have to keep a tab on the rules in order to avoid penalties or missing out on deadlines. Always maintain a research trail. When researching online, be careful, check the veracity of the website and its contents. Use only verified and reliable sources. Be aware of the facts of the case which you are citing. Read the judgment to know what was the decision about. Alright? Do not blindly cite uh, cases, because what happens is this can get really embarrassing. The judge there might know what the judgment of the case was, and just blindly citing may get you in trouble. You will definitely lose scores. So read the judgment. At least read what exactly was passed by the court in that case, and be aware of current affairs, especially those related to your mood problem, nationally as well as internationally. It helps you think on your feet when you're answering during your oral arguments. All right. With that, we begin with the drafting. Let me just. Now, a memorandum has the following contents that you can see on your screen. That is the cover page, table of contents, abbreviations. These are some of this. These may vary in some of them, but this is a standard that most moot competitions follow. Now, statement of jurisdiction, I'll tell you what they are. So, if you see after index of authorities, statement of jurisdiction, that is the statement. This one states the provision of law under which the case has been filed or preferred. So, you have to state the provision of law under which the case has been filed. And this is usually available in the moot proposition, or else you'll have to do your research. How can you identify it from the moot problem? Well, after knowing in which court or tribunal the case has been filed. So this is usually given at the end of the moot problem. So you can check it, identify from there, or what type of case has been filed. Is it an appeal? Has it been filed for the first time? That is original jurisdiction, and so on. So this will help guiding your research. Kind of issues, now there are generally two types: it's the issue of fact and issue of law. And the first issue is generally on maintainability of the petition, that is whether this court has a jurisdiction or the petitioner has a locus standi. And the later issues are substantial law, that is whether any right was infringed, liable for damages, punishment, and any other relief that can be sought. Now, arguments, how do you draft your arguments? There is a systematic manner in which you write your arguments. You cannot just write anyhow. Now, BARAC is the system that you follow. This will be dealt in depth by Diksha in the next segment. This is very important, so make sure that you listen to this part. Now, citations and footnotes are also the most important, because going wrong with them, you can lose marks. You can end in penalty. So read the moot problems and regulations carefully. Form of citation is usually specified in the moot proposition, in the document that contains the moot proposition, the rules, moot rules and regulations. Ensure you follow that. It can either be Blue Book, SILC, that is a standard Indian legal citation. So ensure you follow that, and make sure you stick to the details, that is the font size, the line spacing, and the style of the font. Now the next part is formatting. So guys, you will have to allot at least 2 days for formatting. Ensure that you have this, because doing it at the last minute will not work. Justify the content except the headings, of course, and check for the font size, style, line spacing, para spacing, because ensure you carry on the same format throughout the document. There has to be, uniformity. Although if 2, 3 of you will be drafting it separately, but the document has to be uniform. That will fetch you marks. Ensure the numbering is continuous and page numbers is very important. Although some say it's okay to not have page numbers, I would suggest it. And you have page numbers at the bottom of your what. This is what I do. I have the numbering at the bottom of the page because when you're directing the judges for reference for the purpose of referencing, you during your oral arguments, you generally tell. You generally say, Your Lordship, kindly move to page number 6, para 6 in page number 6. So it's much easier for them instead of them opening any other way. So page number, guys, important. You can use Grammarly to check your grammar. Use the website if you're not confident with your grammar. Abbreviations have to be the same throughout the document and do not capitalize the words unnecessarily. When formatting your headings and subheadings, make sure you do it in a style of that is equivalent to their importance. So, for example, you can start with heading being bold and underlined, then the subheading being just bold, and the heading after that in a different style. Obviously, so this shows the importance of your argument. Before making a soft copy, it is advisable print the entire draft memorial because what happens is sometimes the errors are not noticeable in a soft copy. So when you print it out, it's always visible faster. So this is what I can say. Say this from our experience, from my experience. Like I said, devote time for formatting and review review and proofread your draft numerous times. And every time changes are made to the draft, resend it to your teammates. So what we do is, if I have the first draft there, first draft, I save it as first draft and the date of that particular draft, or say draft 1, number of draft. And if I add or make any changes to that particular argument, I save it as a different. So what happens is sometimes if you want to go back and look what was your original thought of line or line of argument, you can always go back. So this is very important. It comes in handy. Save drafts every time. You will realize this importance once you start, drafting your memorial. And pay attention to the rules. In which form you are supposed to make your soft copy submissions. So sometimes it's the Word document and sometimes it's a PDF. So with that, I end my segment. I know this was a little intensive. You're always open to come and approach any of the Moots members for any clarity on this. Over to Cindy.
Thank you, Shazia, for that wonderful presentation and sharing information on what happens behind the moot. Next, let's have Diksha Garg from 4th year BA LLB for Ace the Case. Over to you, Diksha.
Thank you so much, Sumi, and hello and good morning to my fellow aspiring mooters. I'll just share my PPT. Give me a minute. All right, everyone. So today we'll be discussing and talking about a very simple walkthrough of the oral submissions, which is known as Ace the Case. And when I say oral submissions, it means exactly that. So you need to be mentally prepared that during the course of your moot court, you will have multiple oral rounds in which you will be representing the opposing sides. So be prepared for that. And this is again a very simple walkthrough. Hence, keep in mind that the actual scenario will be much tougher. With that in mind, we'll move on. Okay, I just got a notification saying my network isn't fine. If at any point there is any audio issues, just let me know. All right. The first and most important thing is how you dress yourself, because as important as your speech is, so is the way that you present and your body language. So in terms of dress code, always you have to go in black and white formals unless otherwise specified. Again, ideally, it is not preferable to wear your college uniform because usually college uniforms have a logo or something which reveals your identity. And in the course of a moot court competition, you're given a team court and you stick to that, which means that there is not going to be any revelation of your personal identification. The black and white is obviously corresponding to the actual dress code that the lawyers wear during the courts. Addressing the bench. Now, as Himali and Shazia talked about, bench is basically a panel of judges. Regarding which court you're approaching, the answer you'll find is in your moot court. So keep in mind, always know which court you're addressing. So if you are in a tribunal, you will refer to the judges as sir or madam. If you're in the lower courts, which is district court and below, you will go with your honor. If it's higher courts, that's the Supreme Court or the High Court, you would be referring to them as your lord or your lordship. And if it's the international courts, it's the term used as your excellency. Now, please keep in mind that you really use the proper terminologies. Not all judges obsess over it, but it is good to have knowledge about which court you're approaching and how you address the judges there. Now, under the oral presentation, to understand how you present your case, I will be dealing with three particular things, which is how you structure your speech. Secondly, how do you answer the judges' questions? And thirdly, the general tonality that you might maintain during the course of your presentation. Firstly, before everything else, just keep in mind that you take permission for literally everything that you do. So when you say I seek permission to approach the bench, you are taking permission to beginning the course of your argumentation. Secondly, you will take permission to address the bench collectively or singularly. And in case there is a lady on the bench, please ensure you do term it as, something like this, for example, that may it please your lordship and ladyship for me to continue to refer to this bench collectively as your lordships. It sounds, weird, but these are the procedures that have to be followed. Now, the first counsel, which is the first speaker, so when you are during the course of the moot court, the speakers do not refer to themselves as speakers, but counsels. So the duty of the first counsel is to seek permission to firstly begin the presentation of the case. Second, you talk about the division of the time and issues. For instance, you may say something like this. May it please your lordship to also note that the counsel on behalf of the petitioner would be dealing with issues 1 and 2 and has a time limit of about 6 minutes, and the co-counsel will be dealing with issues 3 and 4 and has a time of 6 minutes. Additionally, if you're combining cases and presenting, combining issues and presenting, kindly mention it within this part. So this is your introductory part. Then you move on to the presentation of the facts of the case. Now keep in mind that usually judges skip over this fact simply for the reason that they've been listening to various teams. So there is a good chance that they will skip over the facts, but you do not go with that assumption. You prepare your speech accordingly, including the facts of the case. Now, moving on, you will take permission to begin the presentation of the issues and arguments, etc. So this is like the initial permissions that you will be taking during the course of your speech. How do you structure? Firstly, form of skeletal arguments and sub-issues. So this is something that even debaters do, that you form an idea of what exactly you'll be talking about, simply to ensure that you have a flow of argument. Again, keep in mind that you are not debating, but you are presenting an argument. You may use your debating skills, but you're still presenting the argument too. So ensure that whatever you tell is backed by authorities, which is what we'll be dealing with when we see the Barak formula. And lastly, please do not make an introduction. So when you do approach the bench, you will not call yourself, you would not address like, I am Diksha Garg and I'm from St. Joseph's College of Law. That is something that you cannot do. You have to maintain complete confidentiality. You may refer to yourself as counsel on behalf of the respondent or on behalf of the petitioner. Moving on. Now, Barak formula, this is something that even Shazia touched about. First thing regarding the Barak formula is that you make a bare assertion, which is basically you map out for the judges what you are going to be discussing or talking about. For instance, you may say something like, my lordship, I will be dealing with the issue number 1 of the moot proposition, which states that the government does not have the authority to enact the present legislation, and in enacting the legislation, the government has breached so and so laws, etc. So once after you are done with stating out the issue and the sub-issue you're dealing with, you move on to the rule and analysis aspect. So in your memorandum, you deal with rule and analysis separately, but when you're talking, you usually combine the two to have a better and a coherent argument. So you can say something like, for instance, if we take the Citizenship Amendment Act, you may say something like the council on behalf of the petitioners submits before this court that the present enactment by the government has violated Article 14. Under Article 14, though there is a provision for the government to make discrimination, this discrimination must satisfy certain criteria. You list out the criteria, and then you give a case law to make the argument much more coherent. Lastly, you move on to the conclusion aspect. So in conclusion, you basically reassert what you started with. So you just say that in line of the above argument, it is extremely clear that by the enactment of the present legislation, the government has violated fundamental rights, and hence the legislation is unconstitutional in nature. So this is one line of argument that you will follow. Now again, key points to keep in mind about your argument is that it should be backed by an authority or a case law. In any situation, you are still presenting a case. So when you are presenting the case, you have to back them by a case law or any other legislation. So according to the hierarchy of authorities, the best is that if you have a legislation or statute which is already supporting what you're saying, go with that. The second best case scenario is you take precedents. Now, I'm sure most of you are aware that precedents are the judge-made laws. So keep in mind that you try to pick up the latest judgments, or you pick up the judgments which are given out by the highest bench. Now, I'm sure most of you must be aware that the highest bench to date to be convened is the Constitutional Bench. Hence, it is always preferable that you take out judgments by the Supreme Court, and the higher the bench, the better for. You may also use books and journals to support your argument, but these do not really have any authoritative value on the judges. You may use them as a persuasive value for the judges to understand the reason behind the enactment of certain laws. Now, in the oral round, you also have a benefit of something called a rebuttal. So the only distinction between a debate rebuttal versus a moot rebuttal is that you attack their authorities first. So during the moot court competitions, one day or some hours prior to the competition, you have something called an exchange of memorandums or memorials. During this exchange, it is always best to look at the authorities which have been cited, because it is quite possible that they have cited a case law which has been overruled, or they have cited a legislation which no longer has any binding value because it has been declared unconstitutional or something like that. So attack these, because these show that you are well prepared on your behalf as well, and you are much more aware of the present legal standings, which obviously increases your points. Coming to the second part of my presentation is how do we answer the questions of the judges. So we'll be looking at three main things again. Firstly, the questions themselves. Secondly, how do you form a differential opinion with the judges? And thirdly, how do you incorporate the materials within the course of your answering? Firstly, to look at the questions themselves. So usually judges are experts in the particular field of law. So they would have certain specific questions with regard to ambiguities and the contradictory nature of law or something like that. So ensure that you are well prepared on these aspects of your moot court. But then you also have the second kind of judges who are basically there just to distract you and to throw you off your argument. The job of these judges is to annoy you into conceding or the argument, or to lose your temper. There's the only way to deal with it is to be very patient and to answer any and every question that they ask. Also, do not automatically take in hostile sort of personality against the judges, because some might even be trying to help you with trying to direct your arguments to a particular important issue at hand. And also keep in mind that these judges have been questioning the same a lot of themes since the rounds have begun. So they might have very specific questions and try to prepare and attack those particular areas within your moot proposition. Second thing, so like Shazia and Himali spoke of, you are prepared or you are preparing for a moot court for about a month or month and a half. While the judges might become aware of the moot proposition only a couple of weeks to um, before to the rounds. So there is a very good chance that you will be much more aware of the proposition and the rules than the judges. So there might be a time where they ask a very irrelevant question, and it might not at all be related to the proposition or what you are speaking or what you're arguing. At this point, uh, you have to basically deal with it. There is no other way to go around it. You can form a slightly differential opinion by saying that, well, my lord, while that may be true, in that case, the matter was dealt slightly differently. Or you might say that, my lord, while that judgment was important, the acts of the government were manifested in a different manner, and in the present instance, the transgressions committed are different. So essentially, just contextualize it and move on. There is nothing else that you can do, but ensure that you're always respectful of the judges, and try to reiterate the titles that you're using. These are just like a couple of tips that you can use. This will ensure that they know that you are being respectful of them. Thirdly, how do you incorporate materials? So now you can prepare a compendium of authorities. A compendium is basically a compilation of the legislations and the case laws that you have used, especially the more important ones, and try to highlight the arguments that you are trying for the judges to read. You can present this compendium to the judges for their referral, and you can flag them. You can basically do anything to highlight your arguments. This also shows the fact that you have been well prepared and you have researched very well. For the speakers, just because you are presenting the oral argument doesn't mean that you can skip the research aspect of things. You need to know the facts of the case. You need to know the facts of the case that you are citing during the course of your oral argument, because at any point in time, the judge can ask you the facts of the case and you need to know the answer to that. Now, coming to the third aspect, the tonality. So, in one word, if I could sum up the general tonality, it has to be respectful. In no case can you disrespect the judge by being argumentative. You have to always be respectful. Secondly, do not irritate the judge and annoy the judge with interventions. So, as important as your delivery is, it is also important that you maintain a proper body language and eye contact with the judges. Like, these are basic public speaking things. And if you feel that the judge is about to ask a question, stop. Let the judge ask his question. Could you want to display the fact that you're confident, but you cannot be arrogant, because these judges, at the end of the day, are experts in their field of law, and you are not giving your opinion on the matter, and you are not debating. You're presenting a case. Hence, you always use case laws and relevant works by jurists to substantiate your arguments. Never lose your temper or concede the arguments that you're making, especially when they're asking questions. Be polite and flexible to the demands of the bench, especially. And please maintain a professional conduct when the opposing side is presenting their case, which means that there cannot be crosstalk between the counsels. Once you're done with your presentation, you can make notes of the points that they are arguing about. You can look at at the authorities that they are citing. It helps you prepare well for your rebuttal rounds. This is something so this is a very introductory thing into the linguistics of the moot life. You will, with regular mooting, you will develop a proper language as such. But for now, these are like certain common phrases that are used. So, in the course of your moot life, or when you're doing your oral presentation, you do not use the word "I don't know" or even the counsel pleads ignorance that way. However, if there is a situation where you're absolutely unaware about whatever the judge is talking about and you cannot in any way deal with it, in that situation, you can always say that the counsel pleads ignorance and would prefer if your lordship could provide certain assistance with regard to the case facts or something like that. Again, whenever the judges grant you permissions to do anything, you can just say "much obliged" and then you move on. Uh, Never use the terms such as "I would like to suggest that," or I would like to suppose that," or "I would like to say this and that." It may please your lord to note that, or it is submitted before this honorable court that These are just general terms. You pick it up while you're doing your practice for your oral rounds. And know that because you're a student, you cannot be perfect. There will definitely be times where you are making an error. And if the judges correct you, do not take it offensively. Just say that you're grateful for their assistance and move on. And despite the mentions in popular culture, you never refer to your opponent as my opponent. You would always call them with their designated party name, the respondent, petitioner, complainant, or appellant, however the case may be. With this, I've come to conclusion. And over to you, Simran.
Thank you, Diksha, for enlightening us all about the minute details which are never to be ignored during a moot. I'm sure we had a very informative session, and this is the time for the Q&A round. We'll be encouraging questions from the students now, and students can key in their questions in the Teams chat box or YouTube chat box, and for those who do not have the option, can always raise their hands. We'll have Joanne from third year BA LLB to moderate the Q&A session.
Good morning, everyone. I hope I am audible and visible. I am Joanne John of third year BA LLB, and I'll be moderating this question answer session. Thank you, Himali, Shasia, and Diksha for those wonderful presentations. And now, if anyone has any questions or queries, please raise your hands or post them in the chat box. The presenters will be answering them. We have a question posed by Rishabh Jain. How to improve one's research skills, especially who is new to moot?
All right. This is on research, so I will take up the question: how to improve one's research skills, especially who is new to moot, right?
Yeah.
Sometimes they say practice is the key. So you need to start practicing and you get better with your research. Their own manner of researching. So when you start, you can probably start reading the books. That is where you get a lot of material from. You understand law. So start reading books. Also, when you're not preparing for a moot, go ahead and read books. Keep yourself updated. The constitution is very important. Also, what you can do is read memos. What I do is I read judgments. So what you can do is go on to any website, Live Law or any of them. They give you judgments. Read the judgments of whichever are being updated, and then you get to understand the language, the manner in which cases are cited. You understand more. So read judgments in your free time, and that is how you develop your research skills. Also, you can explore the websites, that is Indian Kanun, Manupatra, and if you don't have Manupatra, go ahead with Legit Quest. All these websites are really important. So and you can always reach out to us otherwise as well. I hope I've answered your question there.
Joanne, I think you're on mute.
I'm really sorry. We have a question posed by Rishabh. During oral rounds, what kind of language would you suggest? Bit fancy or normal tone? Over to you, Diksha.
It is always better to use a good language. I wouldn't say too fancy as well, but ensure that you have a good language, especially with the tonality. I mean, language part the judges might even overlook, but if you're being outrightly disrespectful towards them, that is something that won't be tolerated in any oral round.
How do we present fact and argument in prescribed time given? Also, what moot court competitions are best for beginners to start with? Himali?
So I'll take the second question first, and then I'll go back to the first one. For beginners, it's usually okay for you to look at the territorial jurisdiction where you were seated in. For instance, like if it's a Bangalore college, one, you choose a college that's close by, so it's easier for you to prepare, and you don't have to spend too much time on travel because it's your first time that you move. Okay. Second is you usually go with, as I told you before, you usually go with subjects that you've already studied, which means that in your first year and your second year, the only subjects you're likely to study are either Constitution, torts, or IPC. So it's usually better to go for a constitutional moot to start off with. So that's that. But otherwise, your area of interest obviously matters. Joanne, can you read out the other question?
Just a second.
Is it something how to present facts and arguments together?
Exactly. How do you present facts and argument in prescribed time given?
So the prescribed time duration that's given for you is for you to talk about the facts and arguments actually. So you will have to make sure you give a bit of your facts as well. But there are some times that the judges tell you to go directly to your arguments as well. So when I mooted, the judges just directly told me to go to the arguments part. So you can seek permission. You can say if the bench is aware of the facts already, can the counsel directly move on to the arguments? And if the judge allows, you can go on. But otherwise, you need to make sure that you concise your facts within 1 minute or so, within a duration of 1 minute or so, and go on with the arguments.
Just to add on before Joanne continues, the main thing in the moot oral rounds is not really presentation of your facts, but it is how you answer the questions of the judges, because they are testing your legal knowledge. So in case you're not able to complete your arguments, that really doesn't matter. Ensure that your prayer you have memorized and that your main arguments you have highlighted. So there is sometimes in the moot round you may feel like it's going on and on, but that's all right. Just ensure that the main the main arguments have been highlighted.
I think I'll add a bit there as well because this is a very important question. Your oral speech has to be separate. So you do not read out from your memorandum. You have to have your oral speech scripted. So what happens is we write beforehand what exactly are we going to speak, which cases are we going to cite. You may cite 10 cases in your memorandum, but pick 2 or 3. That's it. Those that are landmark judgments. So what you do is you time yourself and you do not read out the facts as given in the proposition. You pick out the relevant facts. So if you're a petitioner, you'll read out only the facts as a petitioner. And if you're a respondent, you will read out all facts only as a respondent. So make sure you time yourself, you check yourself beforehand during your mock trial rounds. So you will know how exactly you can fit in within the time.
I see Neeraj Ravindan has raised his hands. Please unmute yourself and ask the questions directly to me.
Yeah. So being a beginner in mooting, like for example, I'm just starting off with moot like from scratch. Is there any particular position that I should go in order to like help myself grow? Like, or does it completely depend on my interest? Like, if I'm a beginner, should I start off with being a researcher, or should I start off with being a speaker? So like, is there any specifications like that?
I'll take up the question if that's fine. So what we have is we have 2 important things coming up after this. The MCS has planned. You'll have your to represent the college at any moot. You need to have your rankings. And it's always advisable as a first timer that you go as a researcher. Keeping this in mind, we have planned things accordingly for you all, and the information of the same will be released soon in the next couple of days. So to answer your question, if I was to say yes or no, I would say go as a researcher, yes. For the next moot onwards, maybe you can go as a speaker because you'll get a first-hand experience of how exactly a moot is, what are the mannerisms that are followed, and how to speak. So you can always look at the other participants. Observation is very important. So, and we have planned things accordingly for you. I hope I've answered.
Thank you. Thank you.
Thank you, Shasya.
Joanne, you're muted.
Still on mute, Joanne.
Am I audible now?
Yes.
Harry Tasvi has raised his hands. Please unmute yourself and ask.
Yeah. So my question was basically like when the judge is asking question, then there is one question to which we don't know the answer. Like for example, he asked the facts of some case we have cited, and we're not sure about it. So how do we handle that?
Okay, so in the most ideal case scenario, there should never be a time where you don't know the answer to a case that you've cited within your memo, especially if you're using this during the course of your oral submission. That being said, if you don't know the answer, what you can do is that you can tell to the judge that you'll be dealing with it at a later stage, just trying to divert and then move on, so that the judge doesn't get too held up on that particular aspect and it doesn't show that you did not know your facts. You can just say that that is a very interesting question, my lord, but the council would be dealing with it during the course of issue 2 or during the course of our oral presentation. And if you would like to bring their attention back to your argument, basically shift it from the question to your argument. I hope that helps.
Yeah. Thank you.
There's a question by Melanie Claire. Is there any particular manner to divide work among the teammates?
Okay. So there is no particular way in which you divide your work. It all depends. One, you can divide on the basis of who is better at it. So sometimes moot propositions have 2-3 statutes involved in one proposition. So let's say there's constitution and IPC in that. So one who is better at constitution can deal with the constitution aspect of it, and the other who feels more comfortable with IPC can deal with the IPC aspect of it. But the idea is that 3 people equally work together. That's how a team works, right? So you need to divide your work equally among yourself, and that depends. And because your moot court is based on your area of interest, there should be some area of interest division that you guys can do.
There's a question from Lojana V. Does the job of a researcher is just to research and not participate in any other manner?
That's an interesting question. Many of them think, researchers' role is not important and just research, and they hesitate to take up the role of a researcher. I'll tell you, I appeared for the researcher's test last academic year, and I was a researcher for one of the moots, despite having been a speaker as well. The role of a researcher is not any less. Remember, the memo best memorial award is given. That reflects. Also, we have best researchers award in many of the moots. So ideally, yes, you restrict it to the research bit. But what happens is when you during the oral rounds. For example, I am a speaker, and Himali is a speaker as well, and Diksha is the researcher. She will have to pass on information or answers to me during the oral rounds. So while I'm at the dais, she will write down the answer. So what happens is many times we do not understand what the answer is, or we do not know. So you have to assist the speaker in answering. Remember, you're a team there. If the speaker performs well, the team performs well. So you have your role. If your question is not participate in any other manner, this is how you participate during the oral rounds. Now, given the scenario of virtual moots, this does not happen. However, you can always, if you are with the speaker at the same place, you can always write and pass the chit on to it. So that's how it is. So it's not limited to the research, but also ensuring that your speaker conveys or answers the questions in a correct manner. So that I hope I've answered it.
Thank you, Shasya. Kushan Kumar, please unmute yourself and ask the question.
Sorry for being late. Actually, I want to ask how to be a question or like after moot court, there's people ask question also like judges or the opposition.
Could you repeat your question? There was some disturbance.
That question hour system.
Are you seeking clarity regarding the questions and answers part?
Yeah.
All right. So the question answers, like I discussed during my presentation as well, it really depends on the questions themselves. So you have to, as you gain experience, you realize whether the question is being asked to derail you or to actually assist you. If the question is to derail you, you try your best to get the argument back to get the focus back to your argument to ensure that the judge is focusing on what you want them to focus. So you would ideally tell them to follow through the compendium that you have presented to them, or you might just say, "My lord, that's a very interesting question, and in this precedence in the council pleads that blah blah blah," and then you, after like ensure that your answers are like within time bound because the question answers etc are included within your older presentation. So ensure that you answer in about like 20-30 seconds, get their focus back to the argument at hand.
Like if you're in moot court nearby in the college.
Yeah, like Shazia also mentioned, we'll soon be coming up with all of the activities that have to be prepared to further assist you for your mooting life. So just stay tuned. There's definitely much more time.
I think we'll take one last question because we are already running late. Okay, so the question from after Supreme Court ruled out using terms like Lord or Lordship, what might be the appropriate term to use? Question by Rejoy James.
Yeah, that's an interesting question, and actually, there was a brief point where I had a debate with both Kamali and Shazia regarding the same issue as well. But yeah, so regarding this, you still go with Lord and Lordship, even if that is not which is used in the actual Supreme Court or the High Court. Obviously, the court ruled it out because they assume that this is holding on to the archaic in the British laws. In the moot court scenario, you still go with this. Like I said, not many judges will obsess over the difference between the terminologies, but not knowing how you address the bench can actually cost you marks. So, with that in mind, just always use the terminologies that I have presented you with.
Okay, so this is the end of the session. We are running short of time, and the questions which are already posted in chat box, we'll be answering them individually during the break time, and you can see them there. Thank you. Over to you, Simi.
Thank you, Joanne. I extend a very hearty gratitude to all speakers, namely Himali, Shazia, and Diksha, for gracing your important work and sharing with us your findings and enlightening us today out on the essentials of mooting. I am sure we all have learned something new. Kindly go through the moot proposition for the next round. As we come to the end of the morning session, I'm grateful towards all the students for patiently staying and listening and coordinating along with us. Remember to fill the form with your full name and your full 5-digit roll number that will be posted on the chat box and write us your feedbacks. Thank you, students, and do join the afternoon session at 1 p.m. after the break. Thank you.